So he lectures both in Japanese and English. Has lectured at Tokyo University, Harvard, Pennsylvania, multiple international conferences and forums. Among his many accomplishments includes a book written in Japanese about informed consent. And he has, in my mind, two very influential articles, one on informed consent in Japan and also another one on unnatural deaths. And he addresses issues of quality improvement in that. It's exciting. He's recently elected the secretary of the East Asian Law and Society section of the Association of American Law Schools. So that means he'll be the chair-elect next year and then the chair in 2 years from now. His current research is looking at quality control and inquiry compensation in Japan and the United States. And he's a very well-rounded person, also with interest in baseball, yaku, and also is very active in the Sierra Club in Arkansas. So maybe you can help me welcome Professor Leflar to the podium.
Thank you very much, Dr. Fetters. I really appreciate the kind introduction. And it's a real honor as well as a great pleasure to be speaking to you here. I am especially delighted to have been invited by my old friend Mike Fetters. And yeah, well, the first time that we saw each other, it's been a few years, but the first time we saw each other, we both noted the changing color of each of our hair. At any rate, what I'd like to do today is introduce to you the current controversy over patient safety reform in Japan. I'm going to try to tell you the story of how Japan has struggled to launch a new system for the review of deaths that occur in hospitals in Japan and for the prevention of medical error. And it's an effort that has puzzled the health ministry. It's divided the medical profession in Japan. It's tangled the nation's health politics. One rather far-reaching proposal was almost passed in the year 2009, 7 years ago. But it got tangled up in controversial politics that year and was shipwrecked by political wrangling. In 2014, at last, the Diet passed a new law that is aimed at addressing review of deaths of suspicious circumstances in hospitals. And the health ministry started implementing that law this last October, so 4 months ago. And it's currently in the process of gearing up the implementation of that law. In June of this year, June of 2016, the Diet is scheduled to revisit the issue, based in part on the experience of these first few months of the new system. And so I think that we're likely to see a further refinement of the law, and it's likewise tangled up in political controversy. So the outcome at this point is certainly unknown. The 2014 law is rife with ambiguity. It's subject to varying interpretations by the health ministry, by the doctors and the hospital administrators who are carrying it out. And it's capable of interpretation in ways that would protect the interests of some stakeholders at the expense of others. And so we're going to start to see an evaluation of this new enterprise. But as you all know, political and social initiatives can be evaluated radically differently based on the standpoint of the evaluators. So here's where I would like to go in today's talk. First of all, I'm going to try to convince you that medical error is in fact a social problem worthy of serious attention worldwide. Second, I'd like to acquaint you with the developments in Japan over the past 15 years or so. I'm going to tell you a few stories about how this came to be an important national issue in Japan. I'm going to tell you about a particular little-known but important project that the health ministry initiated 10 years ago called the Model Project for the Investigation and Analysis of Medical Practice-Associated Deaths. I'm going to give you an overview of the different stakeholders in the political controversy in Japan. I'm going to tell you about some of the key aspects of this new law, the 2014 law, and the battles over its implementation. I'm going to try to explain at least my view of how this law has certain, what I call iridescent qualities, and how the health ministry has chosen to interpret some of the difficult, ambiguous parts of the law. And then finally, I have a few tentative conclusions and predictions to offer. So, starting off, I know that Dr. Fetters is world-renowned when it comes to mixed method research. And so I'd like to talk a little bit about how I do what I do. First of all, I'm a law teacher, and this is what legal academics, certainly in Japan, always do. They start off by reading the government reports, they read the laws, the regulations, the cases, and so forth. And they theorize. But one of the problems that some of us outsiders see in Japanese legal academia is pretty much that's where it stops. What I like to do, what Dr. Fetters likes to do, is take it a bit further and engage other sources of information. I like talking to people. And so what I do is I interview people. And the kinds of people that I interview, first of all, this is about medical error. This is about patient safety, right? So, doctors, the people who are at the bedside, in the wards, in the clinics, right up to the administrators of famous university hospitals. Patients, families, people who have lost their kinfolk due to what they perceive as some kind of medical mistakes. As you all know, health policy, well, policy generally, tends to be quite centralized in Japan as opposed to the United States and some other countries. So you got to go to the health ministry, which sets policy, and in particular to Issei Kyoku, which is the bureau within the health ministry that is responsible for medical policy. And within Issei Kyoku, the Medical Policy Bureau, there is a health promotion desk. And the people of sort of the middle level of the bureaucracy that are in charge of that health promotion desk are the people that run these projects. And so it's very important as a researcher to get to know each of those people. They rotate every 3 years. And some of them are more helpful than others. One of them early on took me down to Kinokuniya bookstore in Tokyo and showed me all the cartoons that I should be reading, the manga, which will help me to understand what really goes on in Japanese medicine. And others have been kind of standoffish. I've had good luck and bad luck with them. Talk with lawyers, both on the provider side, doing medical defense work, working for insurance companies, and on the patient side. And there are very responsible and skilled lawyers on both sides of that. Judges you don't get much out of. I do hear something about how they beat the lawyers' heads together, the defense and the plaintiff's lawyers' heads together, in order to arrive at compromises, settlements of cases, so the judges don't have to write opinions. So, and what goes into apologies, things like that. Politicians, these are the people that craft the legislation that we're going to be talking about. I've been fortunate to get to know a few of those key ones. Academics, a few of them have their feet on the ground, but not many. So that's low on the list. But next are the people that really know what's going on. I'm going to first, I don't think anybody would probably guess this. You talk to people in the insurance companies, the people that are handling liability insurance claims. They're looking day to day at what goes on, and they compile the statistics. So you can really get some good information out of them. But I haven't yet mentioned the single group that is the most helpful in the kind of research that I do. Anybody want to guess? Yes? Nurses. Nurses are important, certainly. And they see the picture at the ward level, at the hospital level. But the people that have the best overview of this kind of research that I find the most helpful are the journalists. The people who really study medical law, medical cases, people who have been watchdogging the health bureau, the health ministry. The people who really have the overview and the particularized knowledge are the people that have been covering this stuff for years. And Japanese newspapers, especially Asahi and Nikkei and to some extent Yomiuri, they are very trustworthy sources of information. And what you do is, you rely on the journalistic ethic. These people are smart. When it comes to facts, the journalism process, the publishing process, pretty much vets the facts that ever go into the paper. And you've got to be somewhat skeptical, but you can rely on the statistics, the facts, the reporting that the journalists that publish in those newspapers do. So that, for me, is a very good source of information. Okay. What we have here is Chrysocroa fulgidissima, in Japanese, tamamushi, the jewel beetle. And you will notice there's an interesting feature of the exoskeleton of this bug. You look at the way that the light reflects on it, it kind of shimmers. If the light comes at a different angle, the color that's reflected seems to change. The Japanese have an interesting, I think it's rather charming, color word. It's tamamushi iro. And I think that's best translated as iridescence. And the reason why I'm making that the center of this talk is I think that the Japanese law and the way that the health ministry is implementing the law, if you look at it from different angles, the color of it changes. It can be interpreted in different ways depending on the perspective, the stakeholders, the politics. Now, here's my venture at trying to convince you that medical error is a big problem worthy of attention. Many of you will remember this. You got hundreds of high school students from South Korea, and they're often on an excursion to Jeju Island, and due to mistakes by the captain, the pilot, the boat sinks, 300 people die. Tragedy. In the newspapers, in this country, right, as well as all over East Asia. So there's one example of a disaster that certainly within Korea has made a lot of difference, and to some extent worldwide. Here's another. No question, that changed the course of history. That changed the course of American policy, world policy, international repercussions, enormous. How many people died? About 3,000. Here's another. No question, that has received a little bit of attention. That has changed the course of history. How many people died? According to the Japan's National Police Agency, about 18,000. Contrast. How many people die from medical error? According to the National Institutes of Health, which, as you know, is perhaps the most prestigious set of research institutions in medicine in this country, relying on the Harvard Medical Practice studies, between 44,000 and 98,000 people die unnecessarily in hospitals every year in the United States. Now, talking about how to trust those figures, the Harvard Medical Practice study, actually two studies, one in New York State, one in Colorado and Utah, representative random samples of patient records from dozens of hospitals in those two states. And since they were randomly selected, they could be considered statistically to be representative of the states as a whole. So extrapolating from those figures, looking record by record by record with trained researchers, nurses, physicians, looking at those records, they came to these estimates. 44,000 in the case of New York, 98,000 in the case of Colorado and Utah. You know, these are estimates, but fairly decent methodology. The estimate is criticized. as being way too low. The Centers for Disease Control has estimated that from contaminated catheters alone, more than 30,000 people die every year. And those ought to be entirely preventable. Other hospital infections. The Department of Health and Human Services has estimated that among the elderly, medical error contributes to 180,000 deaths per year. So all of these figures are estimates, but the point is that the number of people that are threatened by medical mistakes is just enormous. And it's not just in this country, it's elsewhere. What do the statistics in Japan show? Well, the health ministry has come up with an estimate between 1,300 and 2,000 treatment-related deaths per year. Pretty low. Japanese hospitals must be much safer than American hospitals, right? Japan's 1/3 of the population, but much, much fewer than 1/3 of the number of deaths. Well, but look at the source of the data. Hospital self-reporting from 18 selected hospitals that were picked out probably because those hospitals are doing it better than other hospitals. So, I guess we could say this is a lower bound estimate of the number of deaths. Now, I'm going to tell you the story of how Japan started paying attention to medical error. Media attention, I think, in both countries has fallen off since the turn of this 21st century. But the public still has lots of concerns. I got these data just this morning, actually, from Mayamura-san from Nikkei Shimbun. And this shows that in the, this is what I want. About 1999-2000, that's when public attention really peaks. Then it falls off, and now it's headed back up. This is the number of news articles that use either of these two phrases. And so it's something of a reflection of the level of public concern over the problem. Bestseller. You walk into a bookstore last year, the year before, this is on the table at the front. Isha ni korosarenai 47 no kokoro e, which is basically 47 hints on how not to get killed by your doctor. Be sure to read this before you go to the hospital. This is just a photograph of the cover of that book. And it sold hundreds of thousands of copies, just demonstrating that that's still a matter of public concern in Japan and elsewhere. These are international statistics. Different studies about adverse medical events get done in different countries. And you see the percentages of adverse events varies from 3, 4, 5% in the United States, 16% in Australia. The rest of them are someplace in between. Japan, one study shows 6, another 10 to 12. You can't compare one country with another in terms of the safety of the hospitals. The Australian numbers are high because their researchers are very thorough, and they consider a lot of things to be adverse events that our researchers didn't. But the point is, there's a lot of injury that happens in hospitals everywhere in every industrialized country in the world. How many of these adverse events are really serious? Well, here there's something called the Japan Council for Quality Healthcare that collects information about the number of and the types of adverse events. And what we see from their figures, which are probably fairly trustworthy, is that of all the adverse events, almost half, probably there's either no injury or no lasting injury, but 7% of them result in deaths, 39% result in probability of some injury, and a high probability of injury in 12%. So you're looking basically at 1 out of 5 adverse events results in either death or some kind of permanent injury. Okay, here's the story. This started back in 1999. Yokohama City Medical University, a hospital of high repute. You've got one patient who's a lung cancer patient. You've got another patient with a similar name who is a heart patient. And the lung cancer patient has his heart valve excised, and the heart patient has an operation on his lung. Kido Hospital in Tokyo. This is where my daughter and I both went when we were staying over there. In 1999, you've got a nurse picking, instead of the drug that's there in the needle on the table, she picks the sterilizing agent and injects that into the patient. The patient dies. The hospital covers up. The hospital leadership, after conferring with each other, files a false death certificate with the police and misleads the family. Tokyo Women's Medical University Hospital. Not just one, but a whole series of children. This is a hospital of high reputation, especially for pediatric cardiac surgery. And a whole series of children die there. And one of them, this is one of the families that I talked with, the medical record is altered by the doctors to basically cover up the malpractice. And the family, once again, is misled. And this is going to result in claims, lawsuits, and tremendous publicity. The same year, you've got a patient who has a laparoscopy. It's one of those things, they stick a tube with a camera inside and use the pictures that come out of that camera to do the cutting. And so these were 3 inexperienced young surgeons. They probably shouldn't have been doing this surgery in the first place. A lot of bleeding, and unfortunately they got the wrong blood type in, so they couldn't give the patient the blood to replace the blood that was lost. And that patient died too. Once again, a cover-up. The family misled. And all of this led to, they were highly publicized cases, and they all led to a phenomenon that we know as Iryo Fushin, distrust in medicine. And it continues. Same hospital again. Now, how does the court system handle that? The Supreme Court of Japan keeps very reliable statistics on the number of cases filed in each category, including medical negligence. And so these are the statistics on the way that those filings have run. You see, there have always been at least a fair number of cases, and then when it gets to about here, the number jumps up, and then it declines, and then it starts rising again. And 1999 is when those notorious cases began to be in the public eye. That's probably what accounts for part of the jumping up there. So many cases that the Japanese court system launched a whole new initiative to have specialized medical malpractice courts. This is the historical trend line. As you see, got a little bubble right there, but on the whole, that's the way that it goes. Now, that does not take into account claims that are filed outside a court. What I just showed you was just the tip of the iceberg. So in order to get a true sense of what goes on within the legal system, you got to go elsewhere. You got to go to the people that review the out-of-court claims. People in the insurance companies, people in the medical association, which has its own system for evaluating claims of medical error. So, you got to have kind of a strong liver to do some of this. You got, drinking with lawyers and so forth. And one of them is in the Tokyo Medical Association. I'm not going to mention his name, but after 1 or 2 of these sessions, he got permission to give me data from the Tokyo Medical Association that includes their out-of-court claims. And as you see, the historical trend line is pretty similar. Tokyo is, it's not representative of Japan, but what goes on in Tokyo might give you signals about what goes on elsewhere. And so this gives you confidence on the overall picture of the number of claims resulting from what patients think is medical error over the years. Talking with Sompo Japan, this is the major insurance company. They back that up. They say that only about 1/10 to 1/5 of all claims ever go to court. The vast majority are outside. And the number of those has not been going down. It has actually been increasing. And likewise, Tokyo Medical Association, you can see from the pie chart that most claims are out of court. Interestingly, the number that get decided in court, only about a quarter of those patients ever get compensated. But in the claims that are settled out of court, that don't show up in the records, a total of 70% are compensated. Compensation amounts might be large, might be small, but at least some compensation. Now, here's a few other features that I think are important about the Japanese system for compensating medical injury. First of all, in the United States, we have something called a peer review privilege. And that means that something goes wrong in the hospital, there's maybe a committee that reviews that case, there might be morbidity mortality conference, things like that. All of that's confidential. Under the American legal system in every state in the Union, none of that can either be discovered by lawyers or be admissible as evidence in court. And the purpose of that is so that the peer review system can operate freely and people won't be under constraints about what they say. They can really get at the facts and then hopefully maybe do something about it and fix the errors, if there are any, so that they don't occur the next time. Japan has a limited peer review privilege, but according to this Saitama Medical University case, it is not nearly as extensive as the American peer review privilege. And so, for example, if there's an internal report that's done in a hospital about some particular adverse event, that hospital, with the individual views of the reporters redacted, the results of that report, nevertheless, can be obtained by lawyers and can be used as evidence. And so the Japanese privilege is relatively weak compared with ours. Administrative sanctions, pulling of doctors' medical licenses or revoking their privileges or suspending their privileges or making them undergo retraining if they commit a series of mistakes, hardly ever happens in Japan. There's been studies on this, and the numbers are extremely low. The only times that doctors generally get into trouble with their licenses is if there's some criminal conviction, drunk driving or illegal use of drugs, things like that, not medical malpractice. You all have heard about how much American doctors, particularly in specialties like obstetrics and gynecology, neurosurgery, how much they have to pay for liability insurance. Places like Miami, it's enormous. It's tens of thousands of dollars every year. In Japan, $700 per year for independent practitioners. So there's not much pressure from the civil liability system on doctors. One of the most serious kinds of cases are what lawyers refer to sometimes as the bad baby cases, babies that are damaged in birth or in the latter stages of pregnancy. And so they have lifelong birth defects that have to be taken care of, cerebral palsy, for example. And Japan has instituted, since 7 years ago, a system for no-fault compensation of those cases. And so parents of children that are born with these problems have the option of either going to the no-fault system or to the legal system, but it channels a lot of the cases into the no-fault system, away from the legal system. Finally, criminal law has played a really important part in Japan. I'll mention that in a second. I think I'll skip this for lack of time about the obstetrical injury compensation system, except almost all hospitals participate. And the number of cases, 90% of them that go into that system do get compensated. Okay, criminal law. First ground for prosecution is professional negligence causing death or injury. Article 211 of the criminal law. And just negligence is enough for conviction. What negligence means is a subject of debate, but it's up to the prosecutors whether to bring the case or not. They have a lot of discretion in interpreting negligence. And as many of you know, when you're prosecuted for something in Japan, 99% of the time, you're convicted. Criminal code. Falsification of documents submitted to public authorities. For example, the patient's chart is altered, and that becomes evidence. The alteration of that patient's chart is a crime. Most controversially, you have the physician's law, Ishiho, Article 21. And what Article 21 of the physician's law says is that you've got to report an unnatural death, ijoshi, to police within 24 hours of its occurrence. And if you don't, that's a crime. So this is a responsibility of doctors. And you can see how they're whipsawed, and hospital administrators that are generally physicians, how they're whipsawed. Deaths in hospitals occur all the time. And that's where people die, right, mostly. And so if there's a death that has occurred because perhaps of some kind of medical mistake, do you report it or don't you? If you do report it, then maybe in come the police for an investigation. And you've got police walking through the corridors of your hospital, scaring patients, disrupting patient care, searching through your files. If you don't report it and you get caught, like the head of Hiro Hospital in Tokyo with the fatal injection, that case went to the Supreme Court of Japan and he was convicted, and his conviction was upheld. What do you do? This really makes the medical profession nervous. And the numbers are not that large, but they spiked during those early years of this century, and all of those criminal cases were very much in the public eye. So it was a big concern. And there's a lot of pushback from not only the medical profession, partly because these people, doctors don't set out to hurt patients. And so if an objective of criminal law is deterrence of crime, well, it doesn't do any good. These are unintentional. And the punishments, mainly reputational, they might be fined. They don't serve time if they're convicted, but the reputational effect is enormous, disproportionately. What do police know about medicine? They can't understand the subtleties, say the critics. The criminal investigations, as I said, interfere with patient care and, in fact, harm patient care because there's an incentive for doctors not to do risky but necessary procedures where maybe the patient might die for fear of the legal consequences. And finally, one of the points on to err is human is that we got to stop paying so much attention to blaming individuals. We got to start looking at systems, because it's system failures that are really behind a lot of the unforgiving nature of medical accidents. So build in some mitigating aspects into the system. So people are going to make mistakes. We all make mistakes. But when it does, then let's minimize the consequences. We got to design systems that way. And so if the criminal law, since it focuses on blaming individuals and not systems, usually, then the focus is wrong. So those kinds of criticisms were made of the involvement of criminal law in Japanese medicine. And there was one significant case, the case of Ono Hospital up in Fukushima, where an obstetrician lost a patient, a mother, in a difficult delivery, and the police found out about it, and so they show up at the hospital and haul the physician out of the hospital in handcuffs. It's on national TV, totally humiliating. And for the medical societies in Japan, that was just too much. So they started a protest movement. And that movement kind of had a name, Irio Hokai. Law is destroying medicine, is making medicine collapse in Japan. And this had a lot of influence, a lot of public influence, including, I think, probably on some of the judges in these cases. Because, as I mentioned, almost always where there's a prosecution, there's always also a conviction. Well, 4 consecutive cases physicians and nurses that were accused of medical negligence or these other crimes were acquitted, which is a huge embarrassment for the prosecution. And then, to top it off, one of the top detectives in the Tokyo police, who had investigated, for example, the Tokyo Women's Medical University cases, was arrested for falsifying evidence. Again, shameful against the prosecutions. And so you start seeing the criminal law dropping off. The bar at the right is just my estimate based on my counting of the cases. It might be not quite right, but this is more or less the picture. But criminal law still is playing a part in Japanese medicine as a quality control mechanism. You see the number of cases that are reported to police. Whoops, sorry. It's declined, but now it's starting back up. And the number of cases police are sending to prosecutors is still a significant number. So, what this all meant, at least as far as my analysis goes, was, medicine is a major institution in any democracy. In every democracy, their institutions have got to be accountable in some way, right? And publicly accountable. Administrative sanctions aren't working. Malpractice litigation, there's some, but in comparison with the number of cases of medical error, it's not all that much. And since liability insurance is so cheap, that doesn't have much of an effect on doctors' concern with not making mistakes. Hospital accreditation in Japan. Here, in order to get paid by Medicare and Medicaid, you got to be an accredited hospital, so almost all of our hospitals are. In Japan, the reverse is true. You don't have to be accredited in order to be paid by the national health insurance system. And so more than 2/3 of hospitals in Japan are not accredited. You can specialize without being certified in a specialty. Outside the top hospitals, peer review in Japan has been almost non-existent. And so, for lack of anything else, it's been the criminal justice system as a last resort that has brought some accountability to the medical profession. Or at least that was my conclusion. And a quotation from one of the family members, a victim of medical malpractice. For victims seeking the truth, the police are the temple of last refuge. Saigo no kakekomidera. Kakekomidera, those were the temples that women who were abused by their husbands could flee to, and the temple would protect them. Well, if you can't get the information anywhere else, you can at least go to the police, and they'll investigate and find out the truth. So, criminal justice is in retreat. What's going to take its place? The model project. What the model project was a system by which questionable hospital deaths would be investigated not by the hospital itself, that wasn't trustworthy, but by outside specialists. And they would come up with a report, and that report would go to the hospital, to the family, and to the public. And various Japanese medical disciplines participated in this. They agreed that something needed to be done. Because of Idro Fushin, because of medical distrust, they had to regain that trust, and this was one way of working to do that. And they started off with just 4 metropolitan areas. They expanded to 12, which covered more than half of the population of Japan. And it had some great features, I thought. The impartial expert review, the candor toward the public and toward the families. The reports would have guidance for how to avoid these kinds of things in the future. All of those things were definitely had merit. But there were problems. One is that they didn't look at cases of serious injury. They only looked at death cases. And a second is there's a lot of rural areas in Japan that don't have the pathologists that were needed. And so they couldn't go there, basically. So it was limited geographically. And the way that they set it up with 3 physicians doing every review, that was maybe not the most efficient way of operating. So fewer cases. One of the reasons for that was the cases had to be submitted by the hospital management. Patients couldn't submit cases. And so the number of cases was limited for that reason. And the hospitals were concerned, since the peer review privilege is weak in Japan, that the reports might be used against them in litigation. Well, on the whole, though, it was considered a success. It went from 2005 to 2010, and the question was, could this be a model for a nationwide system? Well, the health ministry thought that it should, and so they proposed what's called the Taikoan, the proposed general plan, to establish these regional review boards. And in cases of potential medical error, information would not go to the police, it would go to these regional review boards. And the hospitals would be under a duty to honestly tell families what had happened. And there'd be a central committee, you know, everything in Japan has got to be some central committee, right? And that committee would receive reports from the regions and analyze the problems, make recommendations about avoiding them in the future. And then the prefectures could, if there was a hospital that was really recalcitrant and out of line, then the prefecture could impose an improvement order on that hospital. And so this was the plan back in 2009, and almost unbelievably, okay, here are the, one more aspect of the plan. Move away from reliance on criminal law. The police could still be involved in a very limited number of cases where you've got either intentional death, right? You know, killing somebody off because they're too old. There's a few cases like that. Death from extreme deviation from the standard of care, or altering records. Police could still be involved to some extent, but it would be much more limited. And almost unbelievably, they achieved consensus through the different ministries on this proposal. The police agency, the health ministry, the justice, finance, the diet members, they all came together. Let's go with this. And this was probably the only occasion, at least in my memory, where the patients groups, the patients advocacy groups, and the Japan Medical Association were on the same side. I'd never seen that before. So what happened? There are some anti-regulatory doctors groups that were tied up with the Democratic Party of Japan that torpedoed it. And the reasons they gave, well, all these central committees, too bureaucratic. There's still room for criminal law, which we don't want. And the reports coming out of these reviews might be used against us. And so what happened was the Democratic Party came up with a counter-proposal which said, okay, not outside reviewers, but inside hospital reviewers. Innai Iinkai, jikocho. And this is, the phrase in Japan is jikocho for Iryoban no jikochosa iinkai. And so jikocho is the catchphrase for these kind of committees. And so make them internal, not external. Try to resolve these things out of court and abolish Article 21. That was the Democratic Party's counterproposal. And the Democratic Party came to power. So they shut down the health ministry proposals. But then along came the earthquake, the tsunami, the nuclear meltdown, and the Democratic Party didn't handle that very well. They were swept out of power, and that created the possibility of the 2014 law, which is where we go now. Article 21 doesn't change that. Okay, here's the new system. The healthcare facility, mainly the hospitals, the support organizations, the family, and the independent entity, which is not the police. Yeah. Oh, yeah, I'm sorry. It's almost 1 o'clock, and if there are those of you that need to be elsewhere, please don't hesitate to leave. I've got about maybe 5 or 10 more minutes of my talk together. Okay, here's what the healthcare facility does when there's an adverse event. They notify the independent entity, called the center, and they do an internal case review, which the hospital's got to pay for. They can request advice from the independent entity. They can request advice from registered support organizations. And then they'll explain to the family and report to the independent entity. What happens next? What the independent entity does is it confirms that report, it analyzes the report. Then if there is a request either from the patient side or from the hospital side, then this independent entity, the center, will do an independent review of the situation, sharing costs, and then report back both to the family and to the hospital. So this is going to be the new setup according to the law, but there's controversies that remain. A couple of study committees, and Health Ministry hope to arrive at a consensus. Here are the issues that provoke controversy. First of all, what the law does is it says there's got to be a report and a review and a report for cases of unforeseen deaths in hospitals. Yoki shinakatta. Well, what does that mean, unforeseen? Who decides? By what process? Outside expert reviews or internal reviews? Is the report going to be disclosed to the family in writing, or do they just get an oral explanation? Is the report only about what happened in this particular case, or does the report contain information about how to avoid this kind of accident in the future? Those 4 items were unresolved in the law. The law could be interpreted either way. The law had an iridescent quality to it. This is a group of relatively small to medium-sized physician-owned hospitals, Ihokyo, Iryo Hojin Kyokai. And they objected that hospital administrators ought to have discretion about what events are reportable and what aren't. They said that local hospitals shouldn't be judged by prestigious outsiders from Todai and Keio and places like that because they wouldn't understand local conditions. They said that if you give written reports to patients, well, that's just lawsuit ammunition. And if you got to give a written report to the patient, then the medical providers won't cooperate in the whole process. And they said that if you put accident recurrence prevention measures into the reports, then that too might lead to findings of negligence because the lawyers will say, look what you could have done, but you didn't. So, under the model project, it was the hospital administrator that decided whether to submit the case or not. But you had independent experts that were checked by a central expert committee. You had information that went to the family and to the public, and there was always an emphasis on recurrence prevention. The health ministry buckled under pressure last year. And the reasons that it gave were, this system is about the assurance of medical safety, not the pursuit of individual accountability. This is kind of taken from the philosophy of to err is human, right? And so the health ministry approach gives the hospital administrator 3 safe harbors in deciding what is an unforeseen death. If they explained to either the patient or the family the death was foreseeable, if they write it in the medical record, or if they have a committee meeting afterwards and the administrator, not anybody else, the administrator, determines that it was foreseen, then it counts as unforeseeable and doesn't have to be reviewed or reported. It's internal, the review, not external. Patients can appeal if they want to and get an external review, but basically it's going to be an internal review. And does the information go to the patients in writing? Again, this is ambiguous. The explanation shall be oral or written or both as appropriate, and it's up to the administrator to decide what's appropriate. Again, the iridescent quality of the health ministry's approach. Reports are to be generalized rather than specific. Recurrence prevention is secondary, not primary. And so just my predictions to close it up. First of all, I think that at first, where there are patient deaths under questionable circumstances, a lot of them are going to be classified not as unforeseeable, but rather as foreseeable and therefore non-reviewable, non-reportable. Smaller hospitals can get advice from the support organizations, but some of those support organizations they can control. They're members of the local medical association, and that can be the support organization. They're members of the local specialty organization. That can be a support organization. That's where they'll go for assistance, not to the big fancy national hospitals. I do think that families that request those reports specifically in writing will get them. And I think that there's a strong likelihood, based on conversations with the key politician, which is Furukawa-sensei in the upper house, that we'll have a revision of Article 21 that will narrow and clarify its scope without totally abolishing it. So I think it's important. I think that, peer review, there's progress here. Peer review is starting to take root among Japanese medical practitioners. I think that the reporting obligations over time are going to result in a better factual basis for finding out how much damage there is in Japan from medical error. We'll be gaining information about that, and a lot of it will be reliable. And I think it's certainly true that patients' expectations for transparency are going to continue to ramp up. That is happening and will continue. That can't be stopped. And I think that it's something that others outside of Japan will probably be interested in paying attention to. Thank you very much for your patience. I've gone too long, and I'm happy to take your questions.
So first, I think we should really thank Professor Leflar. He's a great scholar, he's a great storyteller. But why don't you just choose who wants to ask questions?
Sure. Yes.
Thank you so much for the talk. It was really interesting. Quite depressing, of course. I was thinking, oh wait, I went to the hospital in Japan one time. Oh wait. But my question is really about asking you to talk more about how different you see this dynamic compared to what happens with law all the time. I.e., law is subjective, right? Who gets, what gets defined as a particular kind of act or event or intention in any cultural context is, if not iridescent, right, to use your word, something pretty close to it. So I was wondering if you could talk more about how or why you see this to be sort of particularly iridescent compared to all the other kinds of decisions that are being made in legal dynamics all the time.
And so your question is basically about the subjective nature of law.
Yes, because I feel like that's part of your argument.
Yes.
Right? That this law is, it sounds like you're arguing sort of particularly subjective, designed to be even more subjective than most law. And what I'm saying is, because law is almost always subjective in practice, if not in text, right? Are you saying, could you talk more about whether this is somehow especially different or just the same? It's on the continuum of all the rest of the law.
Okay, and I'll do a comparison, if I may, with the United States.
Great, thank you.
I think that, well, beauty is in the eye of the beholder, which is an essential part of your question. And there is a subjectivity to decisions in law, and that subjectivity depends on who it is that's making those decisions. And on that score, there's a big difference between Japan and the continental countries like France and Italy, Germany, and the United States, because the decision maker, when it comes to interpreting facts in Japan, would be the judges who have been trained from the days of graduating from college to be judges as their life career. Whereas the decision maker in civil cases in the United States and criminal cases is the jury, which is designed to be representative of the citizenry as a whole. Now, I'm not saying that there is no subjectivity in the decision making by Japanese judges, because there is. Their decisions are based in part on their life experience, which is fairly limited compared with American judges' life experience, because American judges have been out there in legal practice for a long time. But the Japanese judges' subjectivity is cabined by the new medical malpractice review system that the Japanese courts have set up, which relies quite heavily on medical experts. The judges, not the parties, but the judges, have systems of choosing medical experts from whatever the relevant disciplines are from their local medical university and bringing them in to testify. And the judges really rely a lot on that. And so if you buy the idea that medical judgment tends to be more objective, then that kind of medical judgment is brought into Japanese court system. In the American court system, by contrast, it's up to the plaintiff side and up to the defense side to find their experts and bring them in, and fairly often those experts are not entirely trustworthy. And it's not expert judges, but it's juries that decide. And so there's more subjectivity in the American civil law decision-making process than there is in Japan. Now, when it comes to the administrative side, the revocation or suspension of licenses, that, as I said, hardly happens at all in Japan. And so subjective, objective, it doesn't make any difference. In the United States, that tends to be a professionally decided item. It's people within the hospital that decide who on their hospital staff is going to receive what kind of discipline. Then sometimes it goes to the state medical board of whatever state, but in essence, most of it is within the hospital. And so there again, you know, if medical judgments, judgments of your peers there in your hospital, some of whom are your friends, are somewhat more objective maybe, then there's more objectivity there. So it's kind of a hard call to generalize, but at least on those particular points, I think that you could say that on the whole, the Japanese civil justice system tends to be somewhat more objective than the American system, and especially when it comes to the bad baby cases, most of which are now going into this no-fault compensation system, and that's just objective medical standards. If the baby meets the standards, then that family gets compensated a set amount. And so in that respect, too, the Japanese system tends to be more objective. I don't know if that responds fully to your question, but sure. Yes?
Thank you for the excellent presentation. I have a couple of questions.
Yes.
One is, I'm wondering if you could speak to the role of whistleblower.
Mhm.
It seems to me like there's a lot of cover-up in Japan and for the iceberg, or the entire iceberg of the surface, potential whistleblowers it's been said that they're weak aspects of the computer. So what those roles that might be. That second question is about alternative way of holding doctors and hospitals accountable. The market mechanism, civil society, naming and shaming kind of thing. You allude to the impact of negative reports expose in the media. And if you look at Japanese, system, there's a lot of books ranking different hospitals and rating different doctors and who have got and all that kind of stuff. In the print media, mainstream media, as well as online space as well. Some of that is probably not very reliable. But so if there's a medical malpractice case, I think a lot of people start writing about not just in Shukanshi kind of media, but also in the website. So, but it's not reliable. Right? So I'm not sure what kind of a role that space, my public space might play in holding these people.
Those are two excellent and important questions. Thank you very much. First of all, on whistleblowers. You are absolutely right that whistleblowers have played an important part in bringing into public view some of the problems of Japanese hospitals. In, for example, the Tokyo Women's Medical University case involving the children whose pediatric heart surgery had failed, it was a whistleblower's letter from within the hospital to the family of the victim that first alerted that family to the possibility that anything might be wrong at all. And I don't know the identity of that whistleblower. The lawyer for the family does, and the family does, but they wanted to keep that secret, and that was fine with me. But one of the reasons why secrecy was totally necessary was, as you correctly point out, there aren't protections in Japanese labor law or Japanese public law for people that engage in whistleblowing. So it takes some courage to do that. People are putting themselves at risk. And that case of Tokyo Women's Medical University is not the only one. There are several other cases. I think that Aoto Hospital was the same. It took a whistleblower from inside to bring that into public attention. And so what it means is that the possible presence of whistleblowers within a hospital is something that every doctor in a hospital in Japan has to keep in mind. Now here is a perception that I have received from one of the leading health economists in Japan, and it's a little bit cynical, but I'm going to offer it to you for consideration. Japanese medicine now is signing up for the idea of team医療, team medicine, team healthcare. And it's a way of, trying to integrate different fields of medicine into a single individual patient's care and improve the quality of care that way. Fine, well and good. That's something that American hospitals, European hospitals, all trying to accomplish, team medicine. One of the side effects of that is the prevention of whistleblowing. Because if you're part of a team, then you're not going to betray that team. Whereas, nurses traditionally have had to do everything that the doctor ordered. The doctor wouldn't listen to them. There was no way for them to object. And so that has put nurses in a psychological bind. Nurses know what's going on, as someone mentioned earlier on. And so for a nurse to become a whistleblower is a plausible thing. And so one of the effects of team医療may be to lessen that pressure. Now, the second question that you raise has to do with the effect of the marketplace on medical quality and the type of information that gets out to the public about relative quality of healthcare at different institutions. Which doctors, which hospitals are the best? And just as you say, in bookstores, magazines, there are these rankings of different hospitals, who is tops in which specialty, which hospitals are the best, and so on and so forth. And also, just as you say, the factual basis for those rankings is suspect. Here's what's going on in some American states that has not yet made it to Japan. And this relates back to your question about subjective versus objective. These ratings are pretty much subjective. They're based on reputation, however that's gathered. In New York State and in New Jersey and in California and a few other places, state health departments have been collecting mortality statistics on, for example, cardiac surgery results. And under the New York State Freedom of Information law, those results compiled by the state health department, originally compiled for the benefit of hospitals and hospital administrators, have become public. And in order to make the statistical comparisons fair and reasonable, they are risk adjusted so that every patient who undergoes, for example, cardiac bypass surgery in New York State, not only is the result of that surgery known, did the patient die within a certain period of time or not, but also that patient's individual risk-related information, the heart's pumping capacity, smoking status, age, gender, all the things that go into a risk profile are also accounted for. And the statistical algorithms are quite complex, and physicians, many of them don't trust them. But nevertheless, what it does is it says if a hospital tends to take sicker patients on the whole, then they're going to have more mortality, and that's adjusted for. And so the statistics are risk adjusted. And The statistics are published every year. You can go to the New York State Health Department and find out which hospitals have the best records on cardiac bypass surgery, and which are medium and which are worse. And not only hospital by hospital, but surgeon by surgeon. You have risk-adjusted mortality statistics for each 3-year period. And so in that sense, in some states that can put the money, the effort into compiling those kinds of statistics and putting them out there before the public, you've got objective measures of medical quality. And Japan is much more subjective in that respect. Now, what is the result of doing that? Medical societies, as you can imagine, at first really criticized the New York State Health Department for engaging in that initiative. But then the results started coming in. And no hospital wanted to be at the bottom of the rankings. Hospital administrators started looking at, if we're down here below, we got to do something. And so they started looking at which doctors could handle the more difficult patients, right? And channeling those to those doctors. And doctors themselves didn't want to be at the bottom of the ranking. And so they started sharpening their skills. And so mortality rates in New York State as a whole have been declining more rapidly than in its surrounding states since those statistics have been starting to come out. And so that's the kind of effect that I think that you're looking for in terms of actual objective market forces acting on medical quality. Japan is a long way from that. Other questions? Yes?
I have two questions, if I may.
Yes.
One question has to do with what happens to people whose injuries are less than death? Are they excluded from this process?
They are.
Okay, so they don't get compensated or anything, or they just...
They can be compensated if they file lawsuits. But there are ways in which the filing of lawsuits in Japan is more difficult for many families than it is in the United States. In the United States, typically, say you've got a permanent injury. It's not death, but it's a serious permanent injury, paraplegia, something like that. And you suspect that it's the result of some medical error. Well, you go to an attorney that specializes in that field, and the attorney will do a preliminary investigation at no cost to you. The cost is to the law firm. And the attorney will get the medical records and will have them reviewed by experts in the field that the attorney knows, and then decide whether the case is worth bringing or not. And if the case is worth bringing, and if it results either in settlement or a judgment, then that attorney will get, depending on the contract, somewhere between 1/3 and 2/5 of the total recovery. And so the attorney, it's success-based compensation. In Japan, the system is somewhat different. The patient goes to the attorney, and the patient has to pay an upfront fee to retain the attorney's services, and that could be several $1,000s. And the attorney will, if he or she takes the case, then we'll investigate it in the same way or similar way to in the United States. But if the attorney manages success, either through a settlement or through a judgment, then the attorney typically will take only 15% to 20% of the amount. So there's a financial barrier that patients have to get through in Japan that American patients don't. That's not a complete explanation for a difference, but it's an important difference.
Yep, for sure.
Okay?
The other question I had was, are there any other malpractice or medical error systems that you really like or anything in other countries or anywhere?
Well, I think that some of the Scandinavian countries, for example, Sweden, has a compensation system that is based on a defined set of adverse events that are usually tied to some kind of medical error. And if the patient receives one of those injuries, one of those defined categories of injuries, then there's a public compensation system. And the patient doesn't get a huge amount of money like occasionally happens in the United States. It's this amount of money, but it helps. And in Sweden, unlike until the onset of Obamacare at least, national universal health insurance, so your medical expenses are taken care of there by that system. So, you know, I kind of like the idea of relying less on lawyers and less on the legal process and more on objective compensation systems like that. But in this country, that's a hard row to hoe.
Thank you. Yeah.
Sure. All right.